Hi, everyone. Welcome to the show. Sarah Palin walked into court today for day one of her defamation suit against the New York Times. It is one of the most important media trials in years, and the former governor of Alaska could win it. But first, earlier this week, Georgetown Law School suspended Ilya Shapiro, who just 2 weeks earlier was announced as the new executive director of the school's Center for Constitutional Law. The issue? Well, Twitter, of course. He issued a series of since-deleted tweets about President Biden's pledge to nominate a black woman to the Supreme Court. Shapiro was supposed to begin his new role on Tuesday, but was instead placed on administrative leave pending an investigation by the school. Now, if you look at some of the left-leaning media headlines, you would think his suspension immediately makes sense. According to the New York Times, Shapiro wrote, quote, President Biden would nominate not the objectively best pick, but a, quote, lesser black woman to be the next Supreme Court justice. And if that was the full context of Shapiro's tweets, that would be a serious issue. But that is not what Shapiro wrote. In the tweets, Shapiro criticized Biden for not giving more thought to nominating a particular federal judge named Sri Srinivasan, an Indian-born chief judge on the U.S. Court of Appeals in D.C., who was a top contender for President Obama as well. So here's what Shapiro actually tweeted, quote, objectively best pick for Biden is Sri Srinivasan, who is solidly progressive and very smart, even has identity politics benefit of being first Asian Indian American, but alas, doesn't fit into the latest intersectionality hierarchy, so we'll get lesser black woman. Thank heaven for small favors. He followed up with, quote, because Biden said he's only considering black women for SCOTUS, his nominee will always have an asterisk attached, fitting that the court takes up affirmative action next term. Then came a third tweet asking, is Joe Biden racist and sexist for saying his Supreme Court nominee will be a black woman? Now, that led to an outcry from students, faculty members, alumni, many of whom have now demanded that Georgetown fire him. He's also a constitutional law expert at the libertarian think tank, the Cato Institute. The next morning, he apologized for his inartful tweet, and he followed up with a more detailed apology the day after that. But not surprisingly, that was not good enough for some. A day after Shapiro was put on administrative leave, Georgetown law students organized a sit-in to protest his continued employment while the university investigates. Now, I'm not exactly sure what they're investigating. We know what he said. Now, Shapiro's tweet was problematic, not because of his opinion that Biden should have cast a wider net, or his belief that Biden is wrong to only consider black women for the position, or that he should pick Judge Srinivasan, but because of how he worded it. And I can understand why people wanted an explanation and an apology. When you say lesser black anything, you need to explain yourself, and they got one. And then they got another. And regardless, though, of how vehemently you disagree with him, he should be able to have views that many others at that law school don't agree with. Shapiro's point is pretty close to one I've made. While diversity on the federal courts, I've said, is a noble goal and, in my view, a legitimate factor to consider when appointing judges, I believe President Biden does his next pick a disservice by having announced that he's limiting the search to black women. And the Biden administration has made it increasingly clear from their releases on other federal judges that they have a checklist of various interest groups that they need to appease with their judicial nominations. You should be able to have that view and not get canceled, in particular from a law school that's supposed to be teaching how to make arguments, not just how to end them. Joining me now is Chris Williams, a writer with Above the Law, who also has a law degree. Thank you very much for coming on the show. Appreciate it. What am I getting wrong here?
Well, first off, it's a pleasure to be here. I think that instead of starting the conversation about where you're getting things wrong, not that I'm, here to push an agenda or anything, I think an important thing that needs to be discussed is that this isn't just an academic voicing his opinions and being canceled for them. This is a person who would be in a classroom teaching. And I could imagine being a black woman in a classroom, it would be uncomfortable to feel as if you'd be judged for the fact of you being there. I mean, as a person who went to a decently ranked law school, this isn't the first time I've heard arguments where people say, oh, because race or sex is considered, there would be an asterisk next to somebody's name by the virtue of the fact that they're present. It's not a conducive learning environment. And I find it strange that it seems like this is being discussed as being in terms of identity politics now, but it wasn't the case when Trump decided to get Amy Coney Barrett. And in about a week after our Ruth Bader Ginsburg died, and he explicitly said that he wanted to have him there, right? This is
that's a separate issue, but that's a separate issue because I've addressed the whole issue about Trump's comments and about Ronald Reagan's comments back in the day, et cetera. And the issue, the fundamental question of whether you agree with Biden or disagree with Biden, I think you'd agree with me that that's not a reason that someone should get booted from the law school. The point that you made is that there's going to be black women who are going to feel uncomfortable sitting in a class where he's teaching. My concern with that reasoning...
As an example. So not just, I meant that as an example. So not just that, oh, black women will be uncomfortable. For example, if a teacher would have said that at Washington University, I would have also felt uncomfortable. I would have been...
Okay, fair enough. Fair enough. I didn't mean to just make it, let's make it broadly, that there will be people who will be uncomfortable sitting in the classroom. The problem with that sort of reasoning is you can say that about anything someone says that is controversial and you disagree with. And you can say, I don't want said professor teaching me because, you know, this person has generally been sympathetic to Palestinians. So if you're pro-Israel, I don't know if I'd feel comfortable as a Jew sitting in that classroom. It just seems to me we just can't go down this road without effectively limiting in a major way who's going to be teaching in elite schools in this country.
Okay. I think that diversity of thought is a wonderful thing to include, whether a professor is a staunch conservative or thinks that there shouldn't be borders between nations. Cool and fine. But I also think it's valid for administrators to consider the thoughts of their students. And there's been a large and very clear vocalization that they would not like to be taught by him. Now, if that is something you think should be considered, cool, but I think it's safe that students should have some role in determining the people that teach them.
The problem with that, though, is the vast majority of students at law schools around the country are going to be left-leaning. There's no doubt about that. And so if the students get to decide who they're comfortable with and, you know, well, I get to decide who I want teaching me, et cetera, we are doing, I think, the opposite of what you just suggested, which is to have a diversity of views. We are shutting down a particular viewpoint. See, I agree that the language, if he hadn't explained it and we left it sort of hanging in the ether, right? This idea that some guy is claiming that because a black woman is going to be chosen, it's the lesser black. He absolutely had to explain that. That in and of itself, taken in a vacuum, unacceptable. But when you look at the context of what he was saying, you can disagree with it. You can still find it absolutely wrong. But in the context, what he was really saying was he thought that a different judge should be picked. And as a result, anyone other than that judge would be lesser.
Well, he's still an academic, right? There was no clear metric he used to justify his claim that the proposed recommended justice is better. He just kind of said off the fly, I think this person would be better. I mean, there was a point.
It's his opinion.
I mean, sure, but if the idea is that academics should be able to profess thoughts, I don't think it's unreasonable to have them explain or justify the opinions they give, especially when they're doing so from a wide platform and they will be representing the schools that they teach on behalf of. I mean, it's also, I think Georgetown has a right to be able to choose who they want representing them, right?
Yeah, they have a right, but I think it's a huge mistake and a real horrible precedent to set if they do this. But Look, it's an interesting conversation. It's important. I appreciate you engaging with me on it. Chris Williams, thank you for coming on the show. I appreciate it.
Thank you.
Coming up, after a delay due to COVID, Sarah Palin finally getting her day in court against the New York Times, suing them for defamation. This is a huge case that could have big repercussions in the media. And hey, it pits Sarah Palin against the New York Times. So, of course, it's interesting. That's next. After a controversial and tumultuous delay due to Sarah Palin coming down with COVID, the former Alaska governor's courtroom showdown against the New York Times got underway in Manhattan today. Palin is suing the Times for defamation for an inaccurate editorial it published about her in 2017. And whatever you may think about the former Alaska governor, she does have a legitimate gripe here, and it's possible that the New York Times could lose this. This is one of the most important media trials in many, many years. Now, the dispute stems back to a 2017 op-ed published by the Times in which they falsely claimed there was a tie between ads run by Palin's super PAC and the 2011 shooting in Arizona, which killed 6 people and severely injured Congresswoman Gabby Giffords. They made a connection between the shooting, committed by Jared Loughner, with a map that Palin's super PAC had put out, which had a sort of stylized crosshairs over 20 congressional districts, including Giffords. But an investigation turned up no evidence linking Palin's map to the shooting. Now, here's where it gets interesting. The Times commissioned an editorial in the wake of the shooting at that congressional baseball practice in 2017, which Representative Steve Scalise was shot. It referenced the Giffords shooting as a prior act of political violence. Now, listen to this. This is how the paragraph initially read. It said, just as in 2011, when Jared Lee Loughner opened fire in a supermarket parking lot, grievously wounding Representative Gabby Giffords and killing 6 people, including a 9-year-old girl, Mr. Hodgkinson's rage was nurtured in a vile political climate. Then it was the pro-gun right being criticized. In the weeks before the shooting, Sarah Palin's Political Action Committee circulated a map of targeted electoral districts that put Ms. Giffords and 19 other Democrats under stylized crosshairs. Now, that passage was very careful not to say there was a direct link between the Palin map and the shooting. But then the New York Times opinion editor, James Bennett, who's no longer with the paper, edited the piece. He edited that paragraph and replaced it with this. It's important. In 2011, when Jared Lee Loughner opened fire in a supermarket parking lot, grievously wounding Representative Gabby Giffords and killing 6 people, including a 9-year-old girl, the link to political incitement was clear. Before the shooting, Sarah Palin's Political Action Committee circulated a map of targeted districts that put Ms. Giffords and 19 other Democrats under stylized crosshairs. Went on. Though there's no sign of incitement as direct as in the Giffords attack, liberals should, of course, hold themselves to the same standard of decency they ask of the right. Now, you can see there, the part about incitement was wrong. So the Times was forced to issue a correction. But here's the legal wrinkle. That error alone is not enough to win a defamation suit. Thanks to the landmark 1964 New York Times versus Sullivan case, Palin has to prove that the Times didn't just get the story wrong, but that they, and in this case, James Bennett, knew what they were printing was wrong, or at least had serious doubts about it. Today, in his opening statement, an attorney for Palin argued that Bennett and the paper had a bias against conservatives. Quote, Bennett had his narrative and he stuck to it. They think they can do whatever they want. They're the New York Times. Joining us now is Bill Gruskin, longtime journalist turned journalism professor, previously the deputy managing editor of the Wall Street Journal, currently the first ever Alan Moorhead journalist in residence at the Judith Neilson Institute in Australia. Bill, appreciate you coming on first thing in the morning in the land down under. From a journalistic perspective, how bad was what the Times did here?
Well, thanks for having me on, Dan, and hello from Australia. What they did was pretty bad. What you had here was, as you just noted, the editorial writer in the Washington Bureau put together a pretty carefully crafted piece on Deadline about this horrific shooting. She sent it up to New York, and James Bennett, who was the editorial page editor at the time, decided he needed to give it a bit more spin, as they say, try to goose it up. And he was doing it on deadline. He was adherent to the print deadlines, and they were coming up very quickly. So he put in these lines that drew a much closer connection between Sarah Palin and the shooting that so grievously injured Gabby Giffords and resulted in the death of 6 others, including a federal judge. And the thing just went in the paper. And it also went online, and within half an hour or 45 minutes, Twitter exploded because lots of people, including liberals like Chris Hayes, said, I think Chris's actual quote was, "This is nuts. This is not true." And so that's something that you never want to do as an editor, which is insert errors into your reporter's copy. It's one of the cardinal sins of journalism.
So Palin's lawyers arguing that the Times bias in general is relevant. How important do you think that will or should be in this trial?
Well, as you know, Dan, when you're talking about a libel suit involving a public figure, and God knows Sarah Palin is as public a public figure as you can get, you have to show one of two things. One is either actual malice. In other words, the people in the newsroom just got up that morning and wanted to get Sarah Palin, and there's really no evidence of that. Or you need to show what's called the reckless disregard for the truth. In other words, you were so careless and so irresponsible that you didn't really pay much attention as to what was true or what wasn't. And that's where they have a somewhat stronger case, because it was well known by the time James Bennett rewrote this editorial that any connection to Palin's crosshair map was just simply not accurate. So that said, it is very hard in the United States for a public figure to win a defamation suit for very good reasons.
Well, and when you talk about winning, we're talking about damages, right? And the reality is that I don't think Sarah Palin has suffered any damages specifically as a result of this. She's saying she suffered $400,000 plus of damages. But it seems to me this is kind of a win-win for Sarah Palin, which is someone's clearly paying for this lawsuit. I don't know who it is, but this is an enormous amounts of money, potentially millions of dollars in legal fees that someone's paying for Sarah Palin.
Right.
On this. And it seems to me she wins the lawsuit, right? And the New York Times loses, and that's really embarrassing for the New York Times. Or she loses the case, and then she appeals it all the way to the Supreme Court to try to get the law, New York Times versus Sullivan, overturned.
And if it does make it to the Supreme Court, and that's obviously a long ways off, she has a couple of people on that bench who would be very friendly to that attitude. Clarence Thomas has already voiced interest in taking another look at Times versus Sullivan. So has Gorsuch. There's a 6-3 conservative liberal split on the court, and it would be one hell of a case there. I mean, I think that's a long ways off, and whether her attorneys want to go that far is unclear.
Bill Gruskin, thank you for coming on the show. Thank you for getting up early. Enjoy Australia.
No problem. Thank you very much.
Australia just always seems like
a great day.
Seems like a happy place. I don't know. Seems like a nice place to be.
So far, so good. I have no complaints.
All right, good.
Thank you, Dan.
All right,
Take care.
Coming up, nothing screams I'm a perfect World Cup game venue like 3-degree weather. The cold, too extreme for the opposing soccer team visiting from Honduras, leading to frostbite and finger pointing. Our friends in the sports media are having a frosty field day over it. That's next. A woman in Ohio who admitted to fatally shooting her Army veteran boyfriend during a domestic dispute was acquitted yesterday. A jury accepted her claim of self-defense without hearing her testify and without the defense calling any witnesses. On May 3rd of last year, Audrey Cole, also a military vet, called 911 and told police she shot her boyfriend, Matthew Michael Mott, dead after he attacked her.
My boyfriend was punching me in my face, and I shot him. He's dead.
I'm sorry, what was that?
My boyfriend was hitting me and punching me in my head, and I shot him.
You shot him?
Yes, I shot
Where?
him in his chest.
Okay, is he still breathing?
He's outside now. I haven't been out there to check on him.
The couple reportedly were arguing over their 3-year-old daughter taking medication. Cole had said that Mott beat her and threw her head into a wall before she shot him with an AR-15 she kept under her bed. During the trial, the jury saw a hole in the wall that Mott said Cole's head had gone through. The state argued that, yes, a domestic dispute happened, but when Cole shot her husband, the fight was already over.
There was a fight in that bedroom by her own admission. But during that fight, when she says that her head was put through a wall, she didn't shoot Matt Mott then. If he was on top of her and beating her to a bloody pulp, we may not be here. But she didn't do that. He left that room. That's when she pulled that firearm out from under her bed, went to the closet, retrieved the magazine, and then went into the hall and charged that weapon. And that's when she leveled it and she fired it.
The defense challenged that, arguing that Cole was in a fight for her life.
What was she supposed to do? Was she supposed to wait until he closes the gap between them, grabs the gun, and shoots her in the head? What's she supposed to do? Wait to get beat again? Hope that her head doesn't get bashed into something harder than drywall? Hope that she'll be able to escape this time before she can protect herself? The answer is no. Let's get real. This wasn't a fist fight. Have you ever seen a boxing match on TV where a man who is twice the size of a woman is boxing her? No, of course not. You want to know why? Because she'd be dead.
The jury ultimately sided with the defense. They acquitted her after only deliberating for 4 hours.
As for count 1, that is the charge of murder, the jury has found the defendant not guilty. As for count 2, felonious assault, the jury found the defendant not guilty.
Joining us now, Jesse Weber, attorney and anchor for Law and Crime. All right, so Jesse, for those of us who were not following this case that closely, was this verdict a surprise?
Well, I think I was surprised because I haven't seen a not guilty verdict in a self-defense case in quite some time, other than, of course, the Kyle Rittenhouse case. But anybody who followed this trial shouldn't be so surprised. And I say that because although the prosecution said, look, she wasn't beaten to a bloody pulp, yes, she was armed and he was not, the truth of the matter was that hole in the wall, which you just showed before, that was, by all accounts, made by her head being pushed into the wall. She did have injuries to her head. She didn't run away from the crime scene. She immediately called 911. There was no video of this incident like we've seen in other self-defense cases. And when you're talking beyond a reasonable doubt, there just was too much reasonable doubt here, too many questions, and too much evidence to support the fact that she really was acting in self-defense. And that little part there from the defense saying that you had a man who was overpowering her. He was so much bigger than her. What did you expect her to do? I'm not surprised by the jury's verdict.
And they didn't call a single witness, the defense?
They did not, including the defendant herself, which, Dan, I have to tell you, when I was watching this in real time, I was shocked. Because at the very least, in self-defense cases, you need the defendant to take the stand to explain that fear, what threat she was going through. It's almost expected. But the confidence in the defense to say, we don't think the prosecution met their burden, we're not going to call any witnesses, we're not going to confuse the jury, and we're not going to risk it at all by taking her in the stand, that was confidence and it worked out.
But they did play part of her interrogation by police, where you do get to hear her. And let me play that. This is number one. This is her describing what happened when she spoke to police.
I grabbed my rifle under the bed, and then I grabbed my ammo and loaded it, and I was trying to get out. At that point, it's like I was trying to get out of here. So I was thinking, get out of here. So I'm trying to get out, and then the baby's already asleep in her room. So I'm like, let me just, I don't know. I just came out the room.
You can't really hear. Sorry, I was just asking him to come back to me because it was really hard to hear what she was saying there. She said, I grabbed my rifle, grabbed my ammo. I was trying to get out of here, trying to get out. Baby's asleep. He came down the hall around the corner from the living room, and then I pointed the rifle. He came at me, and I shot him. So just out of curiosity, Jesse, I assume the jury was able to better hear her in court during that interrogation or had some sort of transcript, right?
Yeah, absolutely. They heard that. And it was an important piece of evidence that wasn't even the best for the defense because the argument was she was so calm. She was showing no emotion during this point. You would figure she might exhibit a little bit more. But I'm always of the opinion it's very hard to judge people in those situations, particularly her, who is somebody who said she had PTSD. She was a member of the military. The way they were, they detailed certain events might be different than everybody else. And at the end of the day, the physical evidence backed up what she was saying. So as much as the prosecution can say, oh, she's really not beaten to a bloody pulp, you see the way she looks in that interview, she's showing no emotion, it just wasn't enough. So it was an important piece of evidence that the jury, yes, they heard much better than all of us.
But bottom line is no one at Law and Crime was shocked at the verdict.
Again, I think we were shocked because we haven't seen a not guilty verdict in a self-defense case like that, except for Kyle Rittenhouse. But no, if you followed the case, it made complete sense. If there was a video of this, that would be a very different story.
Of course.
But they just took her word for it. Yeah.
Jesse Weber, thank you so much for coming on the show. Appreciate it.
Dan, thank you as always. Pleasure.
Coming up, I hate to say I told you so, but I did say that Michael Avenatti representing himself wasn't such a bad idea. And now he's probably thinking that too, since the jury, at least right now, appears to be deadlocked. That's coming up next. Well. The jury in the Michael Avenatti criminal trial actually could be deadlocked. Many, including me, mocked some of his defense to federal charges that he stole $300,000 from his former client, porn star Stormy Daniels. But now it appears the jury is divided. This morning, jurors sent a note to the judge saying they could not agree on the main count of wire fraud. The judge told them to go back and keep working at it. They're clearly having trouble coming to a consensus here. Now, some said Avenatti was crazy to represent himself and that it would inevitably lead to a conviction. Others were not so sure. I know this may sound completely crazy, but I'm not sure it's such a bad idea. Avenatti cross-examined his former client, Stormy Daniels, for over 4 hours with zinger questions like, didn't you tell the New York Times that watching me work was like watching the Sistine Chapel painted? And how do you speak with the dead? And something Daniels claims to do. And even quoted back to her something he says she said on a podcast about hoping Avenatti would get sexually assaulted in prison. Daniels' attorney, Clark Brewster, was on this show last week and said this about Avenatti's line of questioning.
But I think to harangue and try to insult and confuse the jury will be not a good strategy.
But this afternoon, in a second note to the judge, jurors asked for a transcript of Stormy Daniels' testimony and the legal definition of good faith. In closing arguments yesterday, Avenatti told jurors he had a good faith belief that he was entitled to some of Daniels' book advance. Quote, let me be clear. Michael Avenatti never committed the crime of wire fraud, he says in the third person. Michael Avenatti never committed the crime of aggravated identity theft. There's insufficient evidence, ladies and gentlemen, to show that Michael Avenatti ever intended to defraud Ms. Daniels or had a scheme to defraud Ms. Daniels. There's insufficient evidence, ladies and gentlemen, to show that Michael Avenatti ever intended to harm Stormy Daniels. The prosecutors argued Stormy Daniels went to the defendant for help. She trusted him as her lawyer. They talked and texted every day. They traveled and appeared on television together. He was supposed to be her advocate. But the defendant betrayed her trust. He stole from her. He lied to her over and over again, all to steal and spend money that was not his. Joining me now once again is Kate Bricollet, senior reporter at the Daily Beast. She has been in court nearly every day of this trial, something I have envied as this sideshow has played out. Kate, thanks for coming back on the show. All right, so where do we stand tonight?
Well, the jury will continue deliberating. This is not a slam dunk case for the prosecution. I think if you were Manhattan federal prosecutors, you might be sweating right now. Just the fact that the jury said today that they cannot reach a consensus. And regardless, I mean, they said this pretty early, and the judge obviously sent them back to continue deliberating. But the fact that they can't agree on count one might be pretty troubling for the prosecution. And that's the top charge, the wire fraud count, that carries up to 20 years behind bars. Because according to the jury instructions, if the jury does not find Michael Avenatti guilty of wire fraud, they can't find him guilty of aggravated identity theft, the second charge. So if they're really at a standstill when it comes to the wire fraud charge, Michael Avenatti could walk from this.
And this would be his second hung jury out of 3 federal cases that have been brought against him. What was most surprising to me, and I think most ominous for the possibility that there'll be a hung jury, is they only deliberated for, 4 hours before saying they were deadlocked?
Yes, exactly. They deliberated 2 hours yesterday after closing arguments. They deliberated 2 hours this morning before they sent that note saying that they couldn't agree. Well, like I said, the judge sent them back to the deliberation room. And they spent the rest of the afternoon there. They'll return tomorrow. And I guess we're waiting to see, is this another alleged crime that Michael Avenatti gets away with? He walked away from his last criminal trial in California last summer with a mistrial. He represented himself. And Avenatti even said at the start of this proceeding that he felt he had the best chance of winning if he went pro se and represented himself.
What did you make of the closing arguments? You were there in the courtroom. Was he effective as his own lawyer in closing arguments?
You know, now that the jury has come back with these questions, it would seem that he was pretty effective. He began his closing arguments with a story about his father being a hot dog vendor. Judge Furman immediately shut that down since it doesn't have any relevance to the facts in the case. And Avenatti was, his trademark theatrical self. He used these sort of food analogies to try to break through to jurors. And the last thing that he said was, the case that the government is feeding you is a plate with a cockroach in the middle of it. And I submit to you that you should return this food. You should return this verdict and find me not guilty. And I think a lot of people were laughing at that language, but now I'm wondering if some of that resonated with the jury, if perhaps they do have questions about the facts that the government presented.
Right. And real quick, do you think that the prosecutors would retry him if there's a hung jury?
I really don't know. I think a lot of people were surprised that they pursued these charges. I've heard a lot of people say, isn't this more of a civil matter between a disgruntled client and her lawyer? But that's a very good question. Are they going to retry him on 2 counts for wire fraud and aggravated identity theft and put in all that energy? I don't know, but a lot of people.
And money.
And money and time. And, would Stormy testify again? She was clearly very, very angry, and there's a chance that she would, but can they really collect the witnesses in the same evidence again? And would they have to make their case somewhat stronger?
Wow. All right. Well, Michael Avenatti lives to fight another day. Kate Bricollet, thank you so much for coming on the show. Appreciate it.
Thank you. Take care.
Coming up, a guy behaving erratically and doing crazy karate moves brings officers to a backyard. When they arrive, the guy won't listen to officers and starts running at them with a weapon. Terrifying moments caught on police body cam. Up next. We are on scene tonight with the Mesa, Arizona Police Department showing the dangers that police officers face every day. In video released last week, a man is seen trespassing into a yard with a metal carpentry tool. Someone inside called 911.
He's welding something. He has something in his hand. Oh, it looks like an angle, like a triangle for measuring. But he's in some kind of compromised state. Yeah, he's doing some kind of karate stuff.
An officer arrived and looked over the gate. He saw the suspect, James Schild, waiting for police with a metal object and a brick. The officer called for backup. Then he was approached by the suspect's brother.
Okay. Is he violent? Is he violent? Is he violent?
14 years, never seen violence.
Schild's mother also tried to get help for her son, calling 911 and saying he ran away.
My son has been using drugs this weekend. We tried to have him be calm and be here, but I don't know where he is this morning, and it's just bizarre what I woke up to. He's got weights on his truck, and can someone come and just and help and help us locate him, and can he get to a facility? He might harm himself. He talked to me last night about committing suicide.
Schild's mother declined police services and was transferred to a crisis line. So officers responding to the situation were not aware of that call as they opened the gate.
Drop it! Drop it! Drop it! Drop it! Drop it!
As officers opened the gate, Schild charged at them as one officer fired a beanbag gun and another deployed his taser. He kept running, getting within striking distance of an officer. He and another officer opened fire on Schild, who was shot. Police gave him first aid until paramedics arrived, but he died on the scene. No officers were injured. The incident is under investigation. Joining me now is Sheriff Fred Herron from Bucks County, Pennsylvania. Sheriff, thanks very much for coming on the show. Appreciate it. All right, so take me through what we just saw on that video from the officer's perspective.
Sure. I mean, the officers have limited information. The original call was a suspect in someone else's backyard, armed with some sort of, weapon, a long pipe, whatever it might be. Now we know after the fact what exactly it was. But the officers have a duty, an obligation, especially now they find out the individual may have been on drugs from the brother at the scene, to investigate and get that person out of that yard, because God forbid the officers didn't take any action and that person would have broken into that house and hurt somebody else. The officers would have been responsible there too. So they engaged the suspect, first using less lethal force, tasers and beanbags. Obviously, we know now the person was high on methamphetamine, most likely never reacted to the taser or the beanbag, and kept charging at that officer, closing the distance. And we know that a distance about 21 feet, they can get at you before you get a shot off. And with that weapon that person had in his hand, he could have injured, if not killed, that officer that was retreating. The officers were retreating. They really weren't left with many options with the information that they had at the time, and unfortunately, this is just a tragic incident.
And I think what people forget, that some people don't realize, is that tasers only work, what is it? It depends, 50%, 70%, whatever the number is. They certainly don't work all the time.
No, they don't work all the time. And then certainly when you have mental health issues and when you're on other substances, especially methamphetamine and crystal meth, is what we found out after the fact, that has a direct effect on the workability of that taser. And when we see that the taser is deployed and it didn't work, and people on phencyclidine, angel dust, any type of hallucinogenic drug, crystal meth, often tasers do not work on those individuals.
Right. And this is a good example, I think, when people say, well, why don't they use less than lethal? And in this case, they did. That's exactly what they did, right? This is exactly what we want them to do at the outset.
This is exactly, they deployed two less lethal weapons, retreating. He continued to come after them. They really were faced with no other alternative. And of course, the question is, well, why didn't they leave him in the backyard? Well, they didn't have all the information. They know for a fact from the 911 call, original call, that it was an unknown subject in somebody's backyard wielding a weapon. Again, what if he would have broken into that house and hurt someone? Now you could have a hostage situation, you could have a barricade situation, or you could have had a situation where he could have killed somebody. On methamphetamine, crystal meth, he might not have known what he was doing.
Yep. Sheriff Fred Herron, thank you for taking us through this. Appreciate you coming on the program.
No problem. Thank you.
That does it for us tonight. NewsNation Prime with Marnie Hughes starts in 5, 4, 3, 2, 1. Thank you for watching. Click the red subscribe button below so you can get more of NewsNation's fact-driven, unbiased coverage.